Okay, I think we can start. First of all, let me say, definitely it is our pleasure to be here for this panel talking about enforcement. That it's actually one of the most, like I would say, because we are here with this panel, one of the most interesting topics to talk about, I must say. So I'm Giovanni Di Gregorio, and I'm the PLMJ Chair in Law and Technology at Católica Global School of Law in Lisbon, and I will be the moderator for this session. I'm the one without the picture, basically. Okay, so basically, just a couple of words, and then before to give the floor to our speakers, just a couple of words of why we decided actually to set this panel, to organize this panel, that actually what it matters, why we are here. The reason why we organize this panel is because most of the attention is very much focused, if you think about even with the Omnibus, pretty much on like the coordination between, like substantive pieces of law and legal instruments and regulation. So, talking about, I don't know, how the GDPR interacts with the AI, with the AI Act, like things, questions related to the DSA, many other questions that are very much substantive. But one of the big questions and challenge for European regulation, broadly speaking, for the European digital agenda is about enforcing all the system that's been created in the last, 5 years, even a little bit more now. So this actually is the big question actually that we're wondering is about what is actually the status of enforcement and where are the problems and the challenges in a system of enforcement that is actually quite important in order also, for European digital regulation to deliver its own promises. So that's actually is the background of the reasons why we decided to, open this conversation. It's a broader project that we are doing also with Simona that is there. And actually, we decided actually to have this conversation here at CPDP. So, but without further ado, I will introduce like basically each speaker. We're going to have like 4 inputs. Basically like on basically an overarching question, and then we will collect your answer at the end of the 4 presentation. That's actually how it's supposed to work. So, and the first one in line is Simona Denkova, that is actually an assistant professor at Leiden University. And Simona is an expert in EU law and also administrative law. That's precisely why, she's perfect in a panel when we talk about enforcement, and particularly enforcement of digital regulation. She has worked actually on different issues related to EU constitutional law, administrative law, and she has also recently published like a book about automated decision making and effective remedies with Edward Elgar in 2023. That is actually one of the first points that lead us to talk about remedies and enforcement. Except for that, apart from saying that with Simona also we are working directly in this month precisely on the topic of enforcement of digital regulation, I will leave the floor to Simona asking the question about which are the constitutional principles that should guide like questions related to enforcement of European digital regulation, considering how fast it's changing and how sometimes, I don't want to use the expression that is a little bit divided between supranational and national, but I wanted just to see which are at least the constitutional guidelines and framework in which we are moving. Simona, thank you so much. For yours.
Thank you, Giovanni, and good afternoon, good evening to everyone. Thank you for joining us still at this very late hour. So the question focusing on constitutional principles that should govern the enforcement of the digital acquis, as I like to call them, I think is very pertinent because the project that we put together with Giovanni, actually, that he mentioned already, focuses on putting enforcement into the light of constitutional challenges that arise from implementing the digital rulebook that we now have in place in the EU. Basically, we can say that the EU has succeeded in a way in designing this rulebook with substantive rules, as Giovanni said, but also what the digital omnibus now shows is that their implementation is perhaps more difficult than would seem at first. So a lot of these questions are being put on the table without clear answers being served because some of it is touched upon by the digital omnibus, but some of it is also left out. And so in my contribution here today, I would like to maybe highlight what are the enforcement challenges that actually put the legitimacy of the digital acquis in question, because they are not only issues that are practical in nature. They are, of course, practical because enforcement is about practical implementation of the laws, but in our views, they are also touching upon the foundations of the EU legal order, such as a supranational legal order that relies on cooperation between the EU level and the member state levels, with the design of procedures that are somewhat too complicated, let's say, and with the many different regulations that have been adopted in silos within different teams, different legislative teams as well. Maybe these questions, these broader horizontal questions, weren't really considered in depth. So more overlapping mandates of the enforcers now become a problem. New forms of composite procedures, or what we administrative lawyers like to call as composite procedures, come to the surface and show the limits of the power or the mandate of one authority when they have to cooperate with an authority of another level, which is here either a an EU level or an authority of another member state. For instance, different guarantees, like the guarantee of independence, which is rather constitutional requirement, now is somewhat put into question because, well, if we think about all these regulations touching upon the fundamental rights questions, then the requirement of independence really becomes the fundamental characteristic of the regulators. But we also know that many of the designated authorities on the member state level may not have the same type of independence as perhaps the data protection authorities would be expected to have, right? So all kinds of questions about what kind of independence is to be desired from the regulators that are now entrusted with enforcement of the digital acquis are relevant to be addressed. And the same now goes for a broader accountability of those regulators, of the enforcers themselves. To whom should they be accountable? If we think on the EU level, for instance, the cooperation between the new agencies like the AI office, should they be answerable to the Court of Justice? Should there be a way to maybe seek redress against the enforcement decisions of a body like the AI office? We don't know what the rules on standing for companies that will be regulated by those agencies is. So there are questions that are fundamental EU law nature, and they are not yet answered, let's say, and I think the digital omnibus doesn't answer them either. This creates, of course, a lot of legal uncertainty. Legal uncertainty is something that the digital omnibus is trying to address for the companies largely, a bit less perhaps for the accountability of the legal order as such, when we think about these questions that I just mentioned. So I would just maybe highlight three key questions or structural issues that really put this constitutional legal system of the EU in a question mark right now. Is the requirement of the independence, the questions of how to organize cooperation between the different regulators on the national level, on cross-border level between the member states themselves, on the EU level between the EU level regulators, the DSA bodies, the AI agencies, the the EDPS, so the supervisor that is also competent in the field. These questions are still to be addressed. And then there is a third layer of challenges that is now coming to the surface also from the digital omnibus, and that's the question of centralization of power to the EU level. With the enforcement of the digital acquis, we see it with the role of the AI office, which is strengthened with the digital omnibus proposal on the AI Act. We'll see what the final version will be, but it strengthens the role of the AI office. And so, being a new body, we have to ask these questions. What is the standing of this body within the broader legal order of the EU when we want to maintain maybe sufficient separation of powers between the different institutions, but also in light of subsidiarity and proportionality principles based on which the EU treaties are, of course, founded. I don't know how long I have still, Giovanni. Okay.
Sorry, the mic was off. You still have 3 minutes. Okay.
Okay, great. So I touched a bit already about on the omnibus what it actually changes in this context. It proposes some new obligations, for instance, on mutual assistance between the national regulators, on exchange of information, but these are kind of practical fixes. They are not, of course, telling the member states how to designate their regulators on the ground. This is something that is subject to national procedural autonomy. This is why we have that kind of a variety in the member states. And it's probably hard to fix through, streamlining of the AI Act itself. But it's a question that perhaps would need its own digital omnibus, if you like, from a procedural perspective, because it's one that needs to be addressed. If we think of case law like the Meta platforms, the case which triggered cooperation between the competition authorities and the data protection authorities, not knowing who has the final say in a dispute that kind of involves questions of both of competition law and data protection law. Here we see that there is a need for more guidance from top down on how member states can structure cooperation between different types of authorities that are designated to enforce EU digital laws. The Court of Justice only resorted to the principle of sincere cooperation in this case because that's the only thing that they could do. They're not the legislator, of course, but having the absence, the vacuum, the legal gap in rules on how the cooperation should look like will create similar problems in the future. The same with the case of WhatsApp against EDPB recently that was decided by the Grand Chamber of the Court of Justice, which showed that new forms of composite procedures still don't have answers. We don't know what the standing against a body like the European Data Protection Board is when they adopt decisions that are binding on national supervisory authorities. Who can go to court, where they can go to court, is it in the member state level, is it at the EU level? This creates, of course, parallel legal proceedings. Perhaps it gives an impression of better legal protection for the companies that are regulated in this case, but it may also create more legal uncertainty for less non this kind of big players as WhatsApp, for instance, but companies that have lesser resources or even individuals if they find themselves in the need to litigate, of course, on these questions. So we'll just close here with saying that we, Giovanni and I, have this project that we are in an academic panel that brought together many experts in the field of enforcement and digital regulation and EU constitutional and administrative law, and we are preparing a Cambridge Handbook on the enforcement of EU digital acquis that will try to address all these constitutional questions through numerous contributions, because of course these questions are too big to be addressed just by each of us in one paper, let's say, but they deserve a broader academic discussion, let's say, and then maybe legislative discussion in another instance. Thank you.
Thanks, Simona. This actually, it's a very good overview to enter the discussion and the topic of having, questions for enforcement that spread across, here the focus has been more, of course, on public enforcement rather than talking about courts, but also when it comes to remedies, this is also about judicial remedies intersecting with the administrative remedies. And the question about the numbers of authorities spreading up, of course, across the member states, and then you have even more power, when it comes to the European Commission, and also this power has been tried to be coordinated also with the digital omnibus. There are some examples like with the DSA, with the AI Act. For instance, we see that there are increasing a question about what shall we do when we have like a substantive framework that very much concern actors that are regulated by more of this legislation, but the enforcement of this legislation is, of course, governed by authorities and entities that are spread across different member states. They are actually sometimes, they have different also, and also the administrative culture of the member states is also very different. That's another important argument that we don't have the time to unpack. That's why also Simona said that we need like a different range of, a broader range of expertise in order to tackle. This is probably one of the foundational issues when it comes about the future of the digital rulebook. And now, without further ado, we'll move we'll move up to the European Commission to talk about enforcement. And I'm very pleased to introduce Lubos Kuklis, from the European Commission. Lubos is really an expert on media law and regulation and media policy, and is a member of the DSA enforcement team at the European Commission at DG Connect. And even before that, among the different roles, he's also served as the chair Overga. Definitely, and he was also the, if I'm not wrong, the director of the Slovak Media Authority. So, like, he's definitely an expert on media law, and he has definitely the right perspective moving from the member state perspective to the European Commission. So, Lubos, please, the floor is yours. Thank you so much.
Thank you very much. And yeah, I'll try to briefly walk you through our thinking in the DSA team when we are talking about the interactions with other legislative framework and other authorities. Of course, the answers are that DSA is not that old, so I can't say that we have all the answers, but at least I think the thinking about it will help you understand our approach and maybe also help us in the future. So, when we are talking about the time of Omnibus, the first thing that we need to say about the DSA is that it's not touched by these changes, by the simplification. So the enforcement of the DSA is going on very firmly. We have 17 open investigations, one already closed. Famously, the DSA delivers really much bigger transparency in the online environment than we ever had before. It delivers the rights to users toward the intermediaries. It helps with the protection of public space from hostile interventions, and very much in our focus now is also protection of minors. You've probably heard about the guidelines on the protection of minors, and DSA really provides for the strongest protection of minors currently anywhere in the world. So with this being said, let's focus first on a bit of how the legislation works, toward the DSA. So in the DSA, the first thinking, and some of you may remember when the DSA was only a draft and it was debated in legislation, there was the thinking that DSA will be a horizontal legislation. It will be so-called lex generalis, general kind of rule book, and then every specific law then will connect to it via lex specialis, meaning if there is no special rule in some other law, the DSA will apply. But this was dropped during the negotiation because it was realized that not every legislation and not every framework work this way, and that the interaction needs to be much more nuanced. So it's still, the DSA is horizontal, and yes, the predominant interaction is that it's a horizontal legislation, and then you have special legislation that can connect to it. But there are some other interactions that are much more nuanced and they need to be interpreted. Now, this was anticipated also in the DSA, and in Article 91 you have a kind of call for the Commission to prepare a report that will talk about this interaction with the legislation. This already happened, so we have that report. It identified 54 other rule books or frameworks or instruments, as we can call it, whatever, that are interacting somehow with the DSA. And yes, like the one of the interaction is the plugin that I just said, but of course there is also a different type of interaction. That means, for example, that there are similar obligations, but the scope is different. So the overlap is not total, but just partial, and it's not easy to pick what rules to apply. So again, there needs to be some kind of very careful interpretation, and also there are moments where the DSA is referring back to some kind of other legislation. So again, different kind of interaction. Now, these things, like in principle, are complementary. So it's not that in principle there is some kind of clash, but again, it is about the interpretation and careful legal work vis-a-vis other partners, and ultimately, very probably also in courts, that will decide what is there. Now, this report also identified overlaps that are clearly there and that we can already work on. I've mentioned protection of minors, that's one of them. AVMSD, for example, Audiovisual Media Service Directive, has a strong child protection movement, and there are the video sharing platforms, which, for example, is YouTube. YouTube is also a platform under DSA, so there may be this kind of overlapping rules. Also, GDPR is addressing protection of minors. So there are more of these, but I won't into detail, but just that you have the picture. But again, the overarching point is that there is a high complementarity between various instruments. But of course, there are moments where we need to be careful, and it requires careful legal work. Now, there's also institutional perspective, because all of the legislation that I mentioned have some kind of governance, right? And you can have like really centralized governance, which, for example, is Digital Markets Act. There's the Commission as a regulator, and that's it. But then you have Digital Services Act, you have AI Act, where you have the Commission, which some kind of role on the, for example, in the DSA, it's because of the very large amount of platform search engines, and this is where the Commission is exclusive regulator. But then you have also member state level regulation, and this is very similar in AI Act. So it's a kind of hybrid system, and then you have also completely decentralized systems like TTPA, which is the Transparency of Political Advertising Regulation, or very famously GDPR. So when these institutions are cooperating, it's not the same model with everybody. It's very different, and again, it can be complicated, but it also needs to be understood that this governance models, was chosen because of the nature of that instrument. So it's not like arbitrary thing. It's something that somehow is working with the system. So there needs to be a way to cooperate between the models. But there's also, of course, overarching coordination, right? On the EU level, among the EU institutions, you have different inter-service groups that are doing just that. But then also, like on global level, you have, for example, situation over the DSA, which has the European Board of Digital Services. There you have different types of regulators. Of course, they are all digital services coordinators as designated locally on the member state level, but these are not the same type of regulators. So you have like majority probably are telecom regulators, but you have media regulators there. You have consumer protection regulators there. So they are covering different territories. And then, for example, when you think about media regulators, I think it's 6 of the DSCs are media regulators too. They are covering both, like Audiovisual Media Service Directive and the Digital Services Act on the member state level. And when it comes to telecom, there's no other overlap. So the synergies are also created just by this. And then you have completely different kind of groupings. For example, famously now under Democracy Shield is the Resilience Center that is gathering different types of authorities. They might not be regulators, authorities, but are gathered because there's an information integrity aspect that needs to be covered and that needs to be protected, and these are coordinating on different levels just because of this. So these types of coordination bodies are created also ad hoc, and this is precisely to overcome the institutional gaps that might exist in different frameworks. And yeah, so this is the how to create some kind of synergies, how to identify the gaps and how to overcome them. But of course, all of this is rooted very much in the rule of law, as was mentioned, in the outline of this panel. And you have fundamental protections. I'm coming from the DSA side, so I can say that the DSA is very much embedded into fundamental rights system. It's mentioned so many times in the DSA, so it's sometimes it's very hard to understand the attacks against the DSA from this perspective, because, for example, just protection of speech is there, on every other page. And the DSA was very carefully drafted because of this, not to infringe on the freedom of speech of the users. So yeah, I will end here and happy to answer any question and looking forward to the discussion.
Yeah, thank you so much, because this has allowed us to bring other pieces together. Just mentioning the perspective of the DSA, you can see all the connections are, and you can imagine not only for VLOPs, but also for online platforms in general, like they deal with the data-driven business models, but there are also platforms that are also implementing AI systems. This means already, maybe of course they are consumer-based and oriented, so this is already like, you can see where are the connections when it comes to the enforcement of this, of the big picture. Especially when part of the enforcement maybe is attracted by the European Commission and part is national, and then you have maybe the one-stop shop mechanism with the GDPR, so it's complicated. So that's actually why we want to unpack and talk about that, because the attention is not really focused there, and there is a lot to say in this space. But without further ado, because we also want to have conversation with you, I will move the floor to give the floor to Angelica before saying that we are going to the level of the member states this time. And because Angelica Fernandez is a legal advisor at the Data Protection Authority in Luxembourg, and plus she has a very important expertise also with UNESCO when it comes to the role of authorities in enforcing AI, generally speaking, the rules on AI. So she's really the perfect person to provide us another perspective when it comes to the problems and the opportunities of enforcement of European digital regulation. So Angelica, please, the floor is yours.
Thank you, Giovanni, and thanks for the invitation. And sorry because of my voice and allergies. So I would like to base my intervention on the two pillars of digital acquis, so the AI Act and the GDPR, and the lessons we learned from the GDPR and the opportunities that come from those lessons with the AI Act. I'm so sorry about my voice. So to start, my first remark will be about the lessons learned under GDPR. So what a decade of application of the GDPR has shown us is that the distance between institutional design of the law and the institutional outcome can be considerable, and that this distance needs to be taken seriously and as a matter of regulatory learning rather than institutional criticism. That's really important. And one of the main lessons to be drawn is that the enforcement model in general requires sustained and continued investment in resources, in coordination, in institutional infrastructure that allows these ambitious rules to have the desired outcomes. The transition from this legislative achievement to enforcement maturity is perhaps something that you, Giovanni, bring a lot to your academic work and has reflected on. And I think is indeed one of the constitutional challenges of the EU digital governance project. So that's very important. And this is why the effectiveness of the application is really the step we are living right now, I guess, as a national authority. I would like to give a very positive, I guess, outlook on this challenge because I think there is a lot of improvement already from the experience that of the early on implementation of the GDPR versus what we're living right now with the early on implementation of the AI Act. And this largely reflects something very positive, which is that there is institutional memory and experience, and that this is a great foundation which effective enforcement can be built on later on. This experience with GDPR also, we learned and been discussed that we need, in general, more enforcement capacity, and that building that capacity, for example, across all member states with different administrative traditions and different resource levels is a project in its own right, and that deserves a lot of attention, and not only to the legislative design, which is perhaps alluding to the Omnibus. And in retrospect, the AI Act gives us this opportunity to apply everything that we learned from the GDPR enforcement from the outset rather than afterwards. And this is a very significant advantage, and one that I think all supervisory authorities are already been using. And a concrete example that I want to bring to illustrate this, and perhaps is something that is not well known, is that there is a European working group of competent authorities on AI, and one of its members is actually here in the audience, which is an informal group chaired by the Dutch Authority of the Digital Infrastructure, RDI. The CNPD, so the Data Protection Authority, participates actively in this group, and we chair the AI Sandbox group. This is an informal network, and this is very important. It's informal, but what is really special is that it was put in place before the entry into force of the AI Act, so while the text was being negotiated. And this already shows a very good reflex of like institutional memory, of knowing that we need to start early on exchanging and figure out how the implementation of the AI Act will work. And also in particular, and this been already mentioned, because of the diversity of actors that will come into play. So there were telecom regulators, there are media authorities also there, data protection authorities, market surveillance authorities, so cybersecurity agents also part of that group. So really all of this, and because of it, then it's really an interesting example, I believe. The group has several subgroups, so there's transparency, cybersecurity, sandbox, high-risk AI systems, etc. And of course, after the AI Act was adopted, now there are obviously the more institutional ways of exchanging information that were given, like such as the AI board. But this particular group, I think, is a great example, even though it's one, about how much commitment there is from all supervisory authorities to counter fragmentation. in one way, to construct a shared vision of what implementation should look like. And because it's an actual extra effort, because it's outside of these mechanisms already given by the law, of trying to build this capacity and to share information and knowledge. There are over 27 authorities because they come from different sectors, even if they're from the same country, and institutions participate in the network, and over 100 civil servants that come together to discuss these things. So I think it's fair to expect that the runway between legislative entry into force and enforcement maturity will be shorter for the AI Act than it was for GDPR, and I think that's a great prospect. Giovanni had asked me before a question about fragmentation, so I think it's very quick to be talking about fragmentation when we are in the early phase of just new digital rules. My second remark is on capacity building linked to enforcement. As Giovanni said, is really a topic that is, I feel, under-theorized and that is dear to my heart. And I want to spend a moment just defining what I mean by capacity building, because it's not simply about budget lines and hand counts, even though that's really important for all supervisory authorities and should not be understated. But it also operates across two distinct dimensions for me, which is technical capacity, so specialized knowledge, investigative tools, which is very important and sometimes very costly, and domain expertise requirement to regulate technologies of complexity such as AI systems. So a supervisory authority that is, for example, in charge of conformity, revising a conformity assessment document, not only needs to understand the legal standards and the technical documentation and all this, but also needs to have a clear understanding of how an AI system is trained, what meaningful human oversight means in practice, and all of these things. And this knowledge cannot be improvised. It must be systematically built, continuously updated, and institutionally retained. And this is true also for data protection authorities when they were dealing with algorithmic processing under GDPR, and they had to learn all of that. And here we have an expert in the room. An authority that lacks that technical knowledge on the assessment of complex AI cannot make right-respecting decisions about it, not because they lack good faith or commitment or the mandate to do it, just because they wouldn't have the competence. And this is why this topic about capacity building is such a crucial topic for enforcement, at least I think so. And the second dimension is institutional capacity. And this we refer to the organizational structures, the procedural frameworks, the interagency relations that allowed an authority to relate and to translate this technical knowledge into effective regulatory action. And here I would like to also offer a second, perhaps not well-known example, but also that speaks a lot to the global dimension in digital regulation for the digital age. The CENPD, it's a co-chair of the UNESCO Global Network of AI Supervisory Authorities since last year, along with the Saudi Data and AI Authority. So this is a network of regulators, basically, of all sectors. The network was launched last summer. It has around 34 members, all supervisory authorities in different capacity, which is explicit recognition of exactly the different shape of AI regulation around the world. And in itself of like the intersectoriality, I guess, that sometimes enforcing AI has. I think it's also a good example of how well EU institutional capacity and experience is perceived in this specific domain. And this is very much influenced by GDPR enforcement experience that is received very much positively around the world. We obtain the chair to a voting process. So this is why I say it's a true reflection of how well we are perceived in general, not only to the credibility of the CENPD, but also in general to European supervisory authorities. And I say this because the work of the European Working Group of Competent Authorities on AI was really what inspired the launch of this network. And then, of course, that credibility that was built with the peers was what allows to win the mandate, but also in general just to launch the network. The ambition of the network is to support peer-to-peer knowledge exchange among supervisory authorities on AI. While the network is in initial stages, so it's hard to speak about more in detail about it or concrete actions, let's say. I think that it recognizes already the mere existence of it, the importance of cooperation across different dimensions of technical expertise and, again, institutional capacity, and also testimony to the incredible commitment to regulatory learning and international cooperation from all the participating authorities, because, again, this is voluntary and it's really at a technical level, so it's not political. So I think there is this real will and ambition to enforce, to build capacity, to enforce correctly, to share a vision of what GDPR, AI, but just in general privacy and AI can do for humanity, because we're talking a global stage. And to conclude, GDPR and AI together represent this constitutional vision for the digital age. And the task is now to obviously ensure that this is matched by institutional reality, and capacity building is exactly how this happens, is how this model of digital governance is not just something nice in the law, in the text, in the design, but it's also effective in practice. And in times of the Omnibus, as the panel title indicates, this effort on capacity building, on talking to your peers, becomes absolutely necessary, whether it's informal, like the example of the European Working Group of Competent Authorities on AI, or formal, like the Global Network of AI Supervisory Authorities at the international level. So this is just two examples that show this, and I think these experiences at a technical level, again, contribute largely and positively to the EU global role in shaping digital regulation. Thank you.
Thank you so much, because definitely, like there are at least two main parts here, that are very, very important. The thing is about the role that also, national authorities plays in digital regulation, and the problem is also the numbers of authority, that are spreading across all the member states, and some member states have decided even to appoint more than one single authority, for the same legal framework, this has happened particularly in the case of the AI Act. But what is interesting is also that we also need to recognize the problem of, what Angelica said about capacity building, that it's a huge question when it comes to different types of authority across member states with different also administrative cultures. So that's why we mentioned that point. And this is very relevant also have in mind what is the perspective from the member states here, because at the end, most of the competencies are at the national level. For good or bad, doesn't matter at the moment. That's actually what we have. And now, it's nice to zoom out a little bit, with the next speaker, because also Bianca is here with us, from the Future of Privacy Forum, from FPF. Now I'm going to introduce her. Of course, she's going to give us a little bit the perspective about what does it mean, what are the challenges of, approaching these challenges of enforcing of European digital regulation in times of Omnibus, also from a global perspective, thinking about what are the real problems there, so we are trying to zoom out after going very, very close to the member states. So a couple of words, of course, to introduce Bianca, of course, that is the Managing Director for Europe at the Future of Privacy Forum at FPF. And she's responsible for all the activities when it comes to data protection, privacy, and AI regulation in Brussels. Nice, particularly this time considering the evolution also with the Omnibus. And also, Bianca has been usually always involved in many events, activities, and also, stakeholders conversation when it comes to this topic. So she's really another, gem here, perfect person, to continue this type of conversation about enforcement, also talking a little bit more about the challenges of the Omnibus approach. So Bianca, please, the floor is yours.
Actually, thank you, Giovanni, for the really overly kind introduction. I don't know if I deserve that, and thank you for convening and organizing this very interesting panel. So I'm going to dive a little bit into the digital omnibus side of the situation in relation to enforcement, and I think first it's important to contextualize this digital omnibus in the broader rule book. I'm still getting to grips with it myself, but indeed digital regulation today is very different today from for example, when I started my journey in data protection doing advocacy and DPO work around 8 years ago. And of course, the technologies and challenges that we're facing today are also not the same as then. So rightly so, we have a broader set of rules for digital life, AI Act, DSA, DMA, cybersecurity, health data spaces. I'm not going to name them all, but there are many. And what's important here is that each of these laws comes with a huge variety of different regulators, data protection authorities, consumer authorities, media regulators, competition agencies. And the fact of the matter is that it's a complex enforcement landscape, and it requires a high degree of kind of sensitivity and collaboration. And I think Angelica made some great examples of existing collaboration. So I'll zoom in on some of the data protection elements of the digital omnibus, because what all of these more recent frameworks have in common is the GDPR, of course, which acts as the foundation of this rule book. Many of the other laws refer to it and rely on it for definitions and cannot go contrary to its principles. So of course, any attempt to modify the GDPR will also have knock-on effects on the broader rule book. I also will give a short disclaimer about the omnibus, because while with the AI omnibus, we saw things moving very quickly, now it's been approved. With the digital omnibus, it's a completely different story. The changes on the table are very sensitive and highly contested and politically uncertain. So where is probably one of the first areas where enforcement might be affected in the digital omnibus context? That, of course, relates to the proposed personal data definition, because it seeks to potentially amend or affect the entire scope of application of the GDPR. So the situation is as follows. Data may not be considered personal data for a specific controller where that controller does not have the means reasonably likely to be used to identify the individual. So here is an area where you can imagine, for example, pseudonymization, anonymization debates really intensifying. At the same time, there's a new Article 41A that would empower the Commission to adopt implementing acts, interpreting when pseudonymized data would not be considered personal data for certain entities. So there's a couple of things to highlight here. First point, and this actually comes from the EDPS-EDPB joint opinion on the topic, which states that this change would indeed narrow the concept of personal data. And then now this is my own interpretation. This could lead to more cases where the GDPR simply does not apply. And of course, this has clear implications for enforcement. So quite simply, if the GDPR does not apply, what DPAs can do remains a little more limited in that sense. The second point that is relevant for enforcement here is if the Commission can adopt an implementing act defining pseudonymization, which is typically within the mandate of the EDPB, what does this mean for potentially diverging definitions or interpretations and consequently on legal certainty? Another point where we see omnibus impact on enforcement is with the proposal to amend Article 12.5 and limit data subject access requests. This is linked to so-called abuse of rights. The thinking behind this is really that there have been an increasing number of cases of requests submitted using generative AI, and DPAs themselves have reported an increase in such requests. In general, the CJU considers that data subjects can submit access requests for reasons other than just becoming aware of data processing and without having to provide a particular motivation. So here, really a balance needs to be found because of course access rights are foundational for the ability for data subjects to exercise other rights under the GDPR, such as objection, correction, and so on, and to be able to assess the lawfulness of processing. It's also one of the ways that a data subject may then decide to either escalate a complaint to the national DPA and so on. So this question also directly feeds into the enforcement impacts. A couple of big picture points that maybe complement a little bit what has been said so far. But the Commission, we've seen, has been taking a significantly more active role as digital regulator over the last couple of years. There's the DSA, the DMA, there's been significant guidance, also joint guidance by the Commission and the EDPB. That's very interesting, for example, on the GDPR and DMA interplay, on GDPR and DSA. Many of you in this room are already aware. So there have been a lot of iterative efforts on all sides to kind of try to streamline and iron out some of these interpretative differences already. And this is independently of the omnibus. There's also another interesting area to watch here around the definition of anonymization, and this relates to DMA GDPR. So for the purposes of Article 6.11, under which gatekeepers operating online search engines have to provide access to search data to certain third-party providers. And what we've seen here is some diverging definitions, which is great for legal folks because this is very small, but the Commission's framework calls for the reduction of re-identification risk to be very low, while the EDPB standard for re-identification risk speaks of insignificantly low. So there are small sort of differences, and we see that there is this pressure where it seems that different thresholds emerge in the DMA context as enforced by the Commission, and a different threshold under the GDPR as enforced by DPAs. And then very final point on enforcement, if I have time, just as it currently stands. So while the AI Omnibus was being negotiated until very recently, enforcement of digital laws has, of course, continued, in particular in the GDPR, but also the DSA. And one area I want to show an example of this regulatory cooperation issue at the enforcement level is around age verification, which is intensifying as a focus area in the EU. So, for example, the Spanish GPA very recently issued a fine for a digital identity company, Yoti, for some failures around biometric data processing in relation to their age verification measures. We saw the EDPB adopted already in February 2025 a statement on age assurance, outlining the necessary data protection compliance processes. At the same time, the Commission obviously has several investigations under the DSA over failures related to age assurance. And most recently, just last month, the Commission issued a recommendation for an EU-wide framework for age verification. So, and this recommendation really discusses a lot the importance of privacy-preserving methods, but nowhere does it mention the GDPR or the EDPB statement or any pre-existing work in the data protection and privacy community on the topic, which is indeed extensive. So, of course, this recommendation is non-binding. It's just sort of a first step in that sense, a soft law instrument, but it gives a bit of an indication as to the thinking on this topic, and perhaps an area where regulatory cooperation is still needed, so we don't miss these opportunities, for alignment. So I'll leave it here for now.
Thank you.
Thank you.
Thank you so much. This adds another bit of complexity about the framework we are going through, especially we will see what is the output with the digital omnibus, because precisely the one with AI is a little bit more advanced with the one with data. So with the one with data, we will see what's going to happen, but definitely it's going to affect, enforcement, because whenever you're touching the rules, of course, it's a matter of interpretation of the rules. But also the one in AI, for instance, there are specific rules trying to coordinate enforcement. I already mentioned that, for instance, when it comes to the relationship between the DSA and the AI Act. So this was actually very interesting, and I would like, first of all, to say thank you for perfect time management. Thank you so much for that. So this allows us to have enough time, I would say more than enough time, I hope, to actually collect questions from the audience. So, and now I see Maria there, 1, 2. So shall we collect 3 questions and then we do a first round there? How should we do that? Mike? Yeah, the first question is down there. I mean, for me, it's down there. Okay. Thank you.
Thanks so much. I'm Maria Magierska from Maastricht University. Thanks, it's a very interesting topic and a lot we can discuss about. So I have actually 2 questions. So one is one that I realize I'm asking since I think 2 years at every CPDP, because it comes up, because we discuss so much this fragmentation between the different the digital acquis. So question on the table is, should we have EU administrative procedure, and are we going into this direction? I saw recently renewal was updated, so we even have rules on the table that we can use from. Do you see any future for that? That's my first question. And the second one is more about the whole design of enforcement as these national authorities and so on. Do you think these frameworks are prepared enough to be to ensure complete independence of the data protection authorities and other authorities against different influences? And I think this is the only panel where we can address this question, the elephant in the room. Like, the elections around the EDPS. So we have the EU institutions itself damaging the whole rules of the system from the way the authorities are selected. So I know it's a bit political. I imagine not everyone will be able to comment on that. I just think this is the only panel where we can have this discussion at least a bit. So thanks a lot.
Thank you so much. Let's I know that you are already. I see that you are jumping. Already. But let's be patient and collect at least other 2 questions, please. So I see another one there, and then we move there. Please, thank you.
Hello, I'm Larissa. I'm a PhD researcher at Erasmus University Rotterdam and also run a consultancy in data protection. My question is to Bianca. My research is about Article 12, Paragraph 5 of the GDPR. And because of this, the Digital Omnibus, of course, it was a moment of joy because I had a lot of research to write about this proposal. And what I want to ask is, how do you see, or what's your opinion about the fact that in the Omnibus we have abusive requests as, let's say, an explanation for excessive requests for this term? Whereas if we look at the jurisprudence of the Court of Justice of the EU, we see that abusive requests is a general category for both manifestly unfounded and excessive requests.
Okay. That's all? Thank you. Thank you so much. 3rd question, and then we do the first round.
There's someone.
Yes, hi. Thank you very much for this panel. I think it's super interesting, and thank you in particular for presenting a little bit this study that you're doing. I think it would be great to hear next year maybe what are the results. I don't know what the timeline is, but it's definitely very necessary to have this approach to really look into the architecture of the different enforcement systems. I wanted to make a suggestion. I didn't introduce myself, sorry. Ursula Pahl from NOIB. The thing is that I miss a little bit the perspective of those who should be protected by enforcement, right? What about the consumers, the users, the data subjects, the affected persons, et cetera, Will you also consider what is at offer for them? What are the complaints mechanisms? We know, for example, the DSA, we have these hybrid systems, as it was called, but we cannot complain to the European Commission. There is no right to complain to the European Commission, which is really a lack. We have huge issues with GDPR enforcement. I don't think that it's a very good model. This is maybe why the one-stop shop mechanism was not followed, and we have now this multitude of different things. Question would also be to the Commission, but I don't know who is in charge there. What does the digital fitness check do in relation to the consistency of these enforcement mechanisms, the principle of effectiveness and the principle of equality, in this case, protection of the Europeans from the diverse illegal practices? But the concrete question I have was also, how do you see what the digital omnibus does in terms of what we see a lot of relativization of concepts, which in our opinion very much makes enforcement not easier, not simpler, and even compliance more complex and difficult. It's not simplification, it's more complexity. What I mean is we have the examples actually that Bianca mentioned. Article 4, personal data definition becomes relative depending on the capacity of the controller. We have the example also Bianca mentioned, 12.5 is the right to access. In the future will depend on the intention of the data subject that has to be assessed by the supervisory authority. So that has to be a psychological exercise. So this is not a simplification, it's a contrary. I just wonder what you think about that. Thank you.
Thanks a lot. So, okay, how should we do that? I think that the first question is about harmonization of admin law. So I will call Simona maybe to answer, right? Please.
I will take it, but it wasn't addressed to me.
It was not addressed to anyone here, so I'm just looking at you,
But
yes.
you're right in asking that. And of course, I'm a bit biased when it comes to saying yes. I think there is a need for a broader horizontal, maybe some sort of harmonization of procedures coming from my background, but I don't think it is the moment that we're going towards, at least that the idea is what the omnibus is touching upon doesn't seem like that there is a discussion focusing on a new regulation that could harmonize procedures across different digital regulations. GDPR regulation of procedural rules and of the GDPR enforcement itself proved to be very difficult to harmonize, right, and to fix. And I think the fixes, you know yourself, were not adequate, perhaps as wished for. So an academic exercise like renewal, update of the rules is welcome. I think it's a good addition to the debate. But I think from the legislative point of view, I don't think there is now the moment for it, even though I would advocate for it to be considered for sure in Brussels, but maybe not, it is not yet on the table. The same thing for the independence guarantees. I think it's a big question that, of course, I already put on the table. It's something that perhaps the Court of Justice will step in to fix for us if the legislation doesn't do it justice, as it did with the DPAs on the ground. Of course, different states had different rules on the designation of national data protection authorities, and the court came with its own notion of complete independence and what it means in practice in different states as the litigation evolved. And I think that may be also necessary when it comes to different regulators across different digital domains. But of course, they are it is a very piecemeal kind of approach, and that one that puts individuals at greater risk, I would say. But I will stop here to give.
No, thanks, Simona. But this is very, very important because, I mean, there is not even harmonization across the different pieces of EU law when they confer power to these authorities, you know, like even there are different approaches to that. So even that would be a first starting point from the top.
But I would say that from EU law perspective, that's where the problem lies,
right,
because of how EU legal system operates, right? There is the national procedural autonomy, and that is a big, important barrier to the EU competence on legislating on procedures, on administrative procedures as such. So I think the root cause of that is the supranational nature of the EU legal system, in which we have the rules emerge.
And subsidiarity, but we're not going to talk about that. I don't know whether Angelica want to say something about design enforcement, since we talk about also capacity building, whether the independence, you know, like from also your perspective, you want to say something.
Not necessarily on the independence,
right?
But I do want to address a bit the idea of having citizens. I mean, the discussion about citizens and enforcement models in general, because I think it's also related in a way to capacity building, but in the other sense is to AI literacy or digital literacy in general, because to be able for authorities to make decisions on right respecting decisions, then you need also the counterparts, or like the citizen, business, and affective individuals to also know their rights. So that's also something that I think maybe it's part of the equation that is being discussed in the Omnibus, of course, but it should maybe get more relevance, of course, just as part of the whole discussion on designing enforcement mechanisms, of course.
Yeah, thank you. And maybe you know, like moving to the question about who is the focus of protection. I don't know whether Lubos actually wants to say something from the perspective of the DSA. So was supposed to, because the DSA has introduced some remedies also that were not there before in the previous legal framework with the e-commerce directive, was pretty much nothing there, you know. So it's also interesting to reflect maybe who sees the addressee of protection when it comes, for instance, under the framework of the DSA, considering the new remedies that have been introduced already. Now it's been some years, and maybe also you can deal with the question about the fitness check and enforcement to see, you know, like whether something is going to change.
Sure. Well, on the users, I'd say that DSA is very strong, of course, because, you know, for the rights that they have toward the intermediaries, that's one thing. But also, for example, when it comes to the risk mitigation, risk assessment by the very large online platform and search engines, there's, for example, a clear requirement to, when devising the mitigation measures, to discuss these things with those that are to be affected by it, so, which means user group, for example. So that's clearly there. Whenever there are guidelines we are issuing, you know, there is a consultation where, you know, we give opportunity to consumer groups to comment on that. It is true that there is no dedicated complaint mechanism to complain to the Commission. It is not true that you can't complain to the Commission, but it's a very general, thing. But we do get complaints. But the DSA, because how it's stacked and how it is envisaged, how many users are affected by the DSA and have interest there, that the process is streamlined via digital services coordinators. This is a design feature of the DSA, so there is not a dedicated a route to directly complain to the Commission. When it comes to fitness, well, these processes are happening, and always, and especially from our part, I'm not familiar with other legislation how this function, but in our perspective, the user is really a center of this. The DSA was designed with the user in mind and to protect the users, not only like special types of users as protection of minors would do, but also like just the users in general. And it goes from both, I would say both sides, because sometimes we are accused that by seemingly protecting users, you are infringing on other users' rights, for example, freedom of speech. But the user perspective is there from both sides. So it's protection of general well-being, for example, but also there's a limit on how much the platforms are required to mitigate or even like allowed to mitigate the risks. So for example, the protection of fundamental rights of the users are such a limit, right? So you can't, like overbearingly try to impose some kind of restrictions on other users because you are protecting some. So this focus is very much there.
Yeah, thank you so much for that. And considering time, and if we want to collect other questions, I think there are at least 2 questions for Bianca as well. One was maybe more on the, the explanation for abusive requests, like in the Omnibus. And the other one was about, maybe also you can deal with the question about how much the Omnibus is becoming not a question of simplification really, but it's more like adding a little bit of more complexity to the big picture.
So on the data subject access request question, I mean, it's very interesting research by the sounds of it, and you're probably much more of an expert than I am. But I'll refer to the EDPB-EDPS joint guidance on the digital omnibus again, because what they suggest as a sort of way forward is essentially to link this notion of abusive request to the existence of an abusive intention on the basis of objective elements. So this should be like intent to cause harm to the controller. I'm not, I'm very skeptical of a sort of an analysis by DPA of the intention of a data subject or something like this. And so I think, on the basis of objective elements, like this addition is very crucial. And in general, I would be, very, very skeptical of questions that are essentially, along the lines of, well, why are you exercising this right? So, and I think this joint opinion does go into some interesting detail around that, and also some recommendations for a way forward, because I think, the digital omnibus, it is going to happen. And so what are some of the ways forward on these issues? And then the second question was about...
It was more about how the omnibus is not very much about simplification only, but it's becoming a little bit the way to justify making things more complicated.
I mean, I don't know if things will be more complicated, but I think there's probably a likelihood that they will be equally complicated, because, I mean, law is law. And so this is just a little bit the process. So, for example, even if the personal data definition does change, there will be a whole new process of guidance, of consultations, of case law, of jurisprudence at member state and EU levels. So the discussion will continue even under this new definition. What, though, may be an impact in the meantime is really a narrowing of the scope and a lowering of the standard of protection of individuals.
Right. Thank you so much for these inputs. Now we'll start, since we have a little bit more than 10 minutes, a second round of questions, if there are. I think there was one there. Any other questions? No, I see just one, maybe Orla. There is another one there. Okay.
Thanks
Please.
very much. I'm Oliver Marsh from Algorithm Watch. I want to pick up on Angelica's point about capacity building, which I also agree is super important. And for advocacy organizations and policy organizations, the ability to support you all externally is super important. I've mostly worked on the DSA, and I think we can say that there's a lot of intention to involve external stakeholders, and we've seen it in the recital 90 that Lubos mentions. But I think we've also seen in practice there are enormous challenges, forget about whether the platforms are engaging, but with being able to engage fully with regulators because of issues of things like confidentiality, process, how much we can be deeply involved. So just for the whole panel, although Angelica raised it, I'd be interested to know how we balance the ability to do external capacity building, give information, know what information you're missing in enough detail to provide it, and not kind of give kind of broad support. How can we balance the issues you have about confidentiality and external engagement with our ability to give you the targeted interventions and support that you might benefit from?
Thank you so much. There is another question, if I'm not wrong, right there. Okay, thank you.
Thank you. My name is Orla Linsky from UCL Faculty of Laws. I have two questions. The first is how the panel see the relationship between kind of private enforcement and maybe some of the opportunities and challenges of having private enforcement run alongside this fairly complex public enforcement structure. And the second question is about how we measure effectiveness or what is good in this area. We've obviously over the last years had a lot of conversation about whether that's the metric is fines, the number of fines imposed, whether it's, some people say if we're imposing fines, we've already failed. It should be about regulatory conversations. Should we be thinking about this on an instrument by instrument basis, or, any thoughts on the metric of what good looks like?
Any other questions? I don't want to say last call, but is there any other question? Okay, so I think we can answer. I think there is a lot to say already. Maybe we can start with the one on capacity building and all the questions about how much we can interact and engage, when things get serious, and Angelica, I don't know whether you want to say something about that.
I want two brief comments, but I think that question is better exemplified in the DSA, where there's already experience when engaging external stakeholders. So that's basically, it's too early on to say, for example, for the Act to engage with external stakeholders, but what would that look like in general? But for example, at the level of the different networks, which are more about knowledge exchange and expertise. They engage. The chairs engage with a lot of different NGOs. For example, I know for a fact algorithmic audit, and a lot of the NGOs work in that space about auditing AI systems, because that speaks a lot about testing, assessment, and things that are very technical and that supervisory authorities need to understand better. So there's been that exchange, and so so that happens. But it's too early to know more structurally how that would look like for national supervisory authorities already working on the day-to-day on that implementation. But on that, and saying, because it's early on, I would also try to talk about Article 77 of the AI Act and implementation, which is between the Fundamental Rights Authority and market surveillance authorities, and how they connect with each other and what they need to learn to be able to, for example, assess a case about something that happened or went wrong with an AI system, and then you'll see that only we are now trying to understand what type of information is needed and engaging with those perhaps other stakeholders that we can qualify as others, or external in a way. So it's little by little, and this is very on. So just to give you an idea of how we manage step by step. But now to Lubos.
Please.
Thank you. It was already mentioned that there's a lot of engagement that we're doing. Also, this is a process where even, we are figuring out what is exact, data, for example, we need for the form of that. So we've heard that criticism from the outside of times that we are not clear about what we are asking, but it took some time to figure that out. But I think we're getting there. So that's one thing. The other is we are constantly trying to figure out the mechanisms how we can support NGOs, CSOs that are working in the area and can support us with monitoring. There's also this part of the DSA that is about transparency. I haven't mentioned it yet, but this is a very strong part of the DSA, that the access to data, for example. So we are also, because we understand that sometimes it's not working as supposed to. So there are also cases open against the platform that are, not doing the job that they are required to under the DSA. So there are different strains where we are doing that. Also, we need to be conscious about a thing that, or sometimes there is such a thing as too much data, for example. So we need to be really careful what we are looking for. And for that, you need metrics, of course. For that, we need external help, with researchers to help us to come up with those things that we are actually looking for. And this, I think, would apply really horizontally to whenever you are trying to figure out whether something is efficient. Now, it also helps that we have audits under DSA, and this is very important because one thing is to have metrics. The other is that you can actually believe what you're getting, right? You have a verified data. And for that, the audits are actually great help because, before that, whatever the platform sent you, you just, took that as a given and, couldn't question it in any way.
Thank you.
Just to add on the capacity building question, because I think it's a really great question and super important. Looking at what is needed, I think maybe I can share a couple of examples of what we do with FPF, which is a lot of multi-stakeholder engagement, where we really believe that obviously DPAs should be part of fora in which they can cooperate with other regulators and other authorities, but also different opportunities to also hear from different stakeholders like civil society, industry, academia, and kind of having them in the same room as everybody else and being able to discuss that way. Foreseeing also what DPAs are concerned about. Fora such as the Global Privacy Assembly is really interesting, particularly the open sessions, which are accessible. And this year, the GPA will actually be in Brussels, so that's also much closer for a lot of people. And also looking at DPA strategic reports, which actually, my colleague Andrea and the audience really analyzes some of these, strategic outlooks for the next year or 2 years or maybe longer, because that always gives an indication, not just of regulatory focus, but also, of course, where input could actually be really useful.
Thank you. Thank you so much also for these inputs. We have 5 minutes and 2 very important questions. Relationship between public and private enforcement and how we measure effectiveness of enforcement. Okay, we have 5 minutes. We can do that. Who wants to start? Simona, please.
I would like to take this question, and thank you so much, Orla, for raising those questions because they are very important and very stimulating for me to think also for the handbook as an editor, because indeed it's something to be thought of. I will take them in the reverse order. The enforcement metric for me is something that would come down to the quality of the law, the quality of the procedures. So when you think about the requirement of foreseeability of the law, so the individuals or the regulated companies or whoever that is subject of the rules is to be aware of where they can turn to exercise their rights, to enforce their rights, or to question perhaps decisions adopted by different regulators that may concern them. So that kind of foreseeability talks about the quality of procedures that are behind the architecture of enforcement. And that would be a metric for me to be used here. And the second element of this metric would be also the legitimacy of the regulators that are then brought into the picture. And here it comes down to the independence guarantee, for instance. So you as an individual or as a regulated company should know, so should be able to be aware of the procedures and who you can turn to. And then if you turn to that enforcer, you should be able to trust that the expertise that is exercised by those authorities is legitimate, in the sense that if there is a conflict of competences between two regulators, you know whose word should prevail and why in certain circumstances. And this is down also to the operation of the cooperation mechanisms. And when it comes to the private and public enforcement mechanisms here, it's something that we also work together with Giovanni on in our article on remedies. If you think, for instance, the complementarity between direct complaint mechanisms that exist under the DSA, where individuals can bring claims directly to the platforms, for instance, you may think, well, the platforms may be better equipped, they may have better expertise to address those claims, of course, than courts or independent supervisors that are outside of the company itself. But then, of course, they may also have their own interests that they wish to protect. They may adopt automated mechanisms to address those claims. So there is a certain complementarity in reducing burden on independent regulators, on the courts, especially when we think about the amount of claims that are possibly emerging in this field. But of course, with checks and balances as they should be when it comes to, the private enforcement should also be subject to checks and balances of public enforcement, let's say, that's my perspective as a public law scholar. Okay, I will give the floor.
Thank you so much. We have 1 minute left, so we don't have time for other questions, as you can see. I don't know whether is there any final remark. Oh, this is on me, actually. Yes, okay, it's on me. Okay, fair enough. Okay, thank you so much. I wanted just to thank all the speakers here. This has been a great, overview of the problems. Of course, you really, this is just the beginning, because as you can see, this is a topic that we need to discuss more rather than always being obsessed about things connected to how we interpret the two legal frameworks together. Enforcement is really important, especially when it comes to the delivery, in terms of comes also to the protection at the end of the people, and the citizens, to which enforcement is, of course, is directed. So, and of course, a brief note to thanks all the audience for this question, to stay with us so late, because it's late compared after a long day. This is the second day already. And of course, thank you so much for being here with us. And we'll see you soon in the next days. Thank you.
Thank you.